Aburabia, our last speaker. Okay. I will start my presentation with a brief story. Samira, a Bedouin woman from one of the unrecognized villages in the Nakab desert of Israel, found out about her husband's intentions to marry a second wife. She decided to resist her polygamous husband. Samira filed a complaint at the Israeli police station. The Bedouin policeman refused to register her complaint, saying, "Do you want to get me into trouble with your tribe?" She went to the head of the police station, an Israeli Jew, that told her, "I cannot do anything about it. It is an internal matter. I suggest you to talk with the sheikh." She went to the sheikh and was told, "I don't understand. What do you want from me? Your husband can marry more than one wife. He is a Muslim, isn't he?" There are no accurate data on the prevalence of polygamy in the Palestinian Bedouin society in Israel, but many estimates indicate that polygamy is about 20 to 36% of Bedouin households. In the last 20 to 30 years, there has been a consistent increase in polygamous marriages at all levels of the Arab-Bedouin society in Israel. Polygamy is increasing irrespective of age, education, or socioeconomic status. In the past 3 decades, there has been a consistent increase in the number of polygamous marriages in the Arab-Bedouin sector in Israel. Under international law, polygamy is perceived as discriminatory, associated with all forms of harms to women, physical, mental, sexual, reproductive, and economic. Under criminal law, polygamy is a criminal offense. However, under the Sharia law that governs family laws for Muslims in Israel, polygamy is permitted. As a consequence, due to the fact that the state doesn't enforce the penal code for the Bedouin citizens, polygamous marriage is valid and practiced. Legal authorities claim that there are evidentiary difficulties in proving polygamous marriages because most polygamous marriages are not registered officially by the Sharia court and take place informally. The approach of the state towards polygamy weakens women and increases their gender-based marginalization, which stem from their increasingly restrictive patriarchal society that encourage polygamy and their ethnic marginality from the Jewish state. According to feminist theory, women are a minority within a minority and shouldn't be sacrificed for the sake of the rights of the ethnic minority to which they belong. There are women's rights that are basic human rights that should never be compromised, even at the cost of changing ancient social traditions. These traditions serve the men and the patriarchal system, and there is no just reason to preserve them when they negatively affect the women of the minority group. The goal of feminism is the eradication of discrimination and the establishment of equality. The case of the Arab-Bedouin women is a clear case of minority within a minority. Traditionally, civil society has been divided into public and private spheres, with women and the family positioned in the private sphere. The exclusion of women in this manner has also influenced their exclusion from this discourse. The control and subordination of women are the basis of the social order. It is important to consider the family when we are addressing the different levels of political organizations and power. Many things are determined at the family level in different societies and countries, to a greater or lesser extent. Family relations and family structures affect the structure of and power relations with the state and civil society. This relationship is bound up in the hierarchy of power of religious and social institutions and their broader relations with class structures of power within the society. A notable portion of the cultural restrictions that women face and the inequality of women can be found in the privacy of the households. Cultural practices that involve the oppression of women can be hidden in private and seen as private family matters that only in exceptional situation might become public issues or matters in which the state might intervene. The distinction between the private and the public plays a central role in the outlining of the boundaries of citizenship. This distinction determines the degree to which the state does or doesn't allow itself to intervene in the private sphere. The granting of exclusive jurisdiction to Palestinian religious communities in Israel in matters of religion transfer these issues to the private sphere. this jurisdiction is considered to be a private concern of religious communities, as opposed to a concern of the state. This is different from the jurisdiction granted to Jewish religious communities in Israel, which are considered part of the Jewish public sphere that is an additional characteristics of the institutions and norms of the state as a Jewish state. Therefore, the positioning of polygamy in the private sphere as part of the marriage and divorce laws, in which the state doesn't intervene and under the exclusive jurisdiction of religious courts, delineates the civil status of Bedouin women in a manner that limits their citizenship. The construction of the boundary between the private and the public is a political act. The state sets the boundaries for intervention, passively or actively, even when it decides not to intervene in a certain practice. Therefore, the question is not whether or not the state intervenes in the private, but rather how it does so. The matter is further validated by the way in which the state reconstructs the concept of marriage. The positioning of bigamy within the private sphere as part of marriage and divorce laws that are under the exclusive jurisdiction of religious courts influence the preservation of patriarchal norms, particularly in the light of the social role played by the family and marriage, as unjust institutions in which women are more often harmed, vulnerable to exploitation, and abused economically and socially, in light of their traditional roles as the ones who have the main responsibility for raising children. The harm to women begins early in the social structure that emphasizes the marriage of daughters over that of sons and their main role as the ones who are primarily responsible for raising children, which affects their professional choices. Therefore, as long as there is no justice in the family, women will not be able to experience equality in the political sphere, the workplace, or anywhere else. By not intervening in the practice of polygamy, which oppresses women, the state preserves the institution of marriage as a patriarchal institution, and in doing so, exacerbate the harm done to Bedouin women. The matter is further exacerbated by the inferior civil status of these women as Palestinians in a Jewish state, not only relative to the status of men, but also due to their belonging to an ethnic minority that is excluded and discriminated against and as part of the tribal society. The ambivalence of the Israeli legislature and the legal system violates human rights of Arab-Bedouin and creates a situation in which they are excluded from the law by the different legal system, criminal law, the Sharia, and customary law. It raises significant questions about Arab-Bedouin citizenship and human rights and about the role of human rights organizations in applying human rights discourse and norms in cases of minorities within minorities group. It also raises legal and moral dilemmas in litigating cases of the Arab-Bedouin minority. I want to share some of these dilemmas with you. The first dilemma, I call it Bedouin women or human rights attorneys, drawing the boundaries between the personal and the professional. As a woman, part of the Bedouin community, representing my own community, but also criticizing it on a feminist ground, when I was entering the unrecognized Bedouin villages in order to meet with my clients, most of the time I was the only woman, and it wasn't an easy experience for me. Although I was allowed to enter the sacred place of men, the shig, I didn't know what to do with myself. Should I ask my clients to bring more women in order for me to feel more comfortable? Or maybe my entrance into these villages by itself breaking the private-public dichotomy. Sometimes the feeling was that I was perceived by my male clients as half women or one of their own. At first, I felt that I have to adopt masculine behavior, be more assertive, dress in a certain, of course, it's the way that society constructs this masculine behavior or feminine behavior, but we will go on the stereotype. Be more assertive, dress in a certain way, in order to protect myself in a sense that I didn't want to draw too much attention as a woman. I wanted to be judged according to professional standards and not according to feminine standards. But after a few years, I was confident enough at my professional position, and then I allowed myself to be more feminine. It was especially apparent during my pregnancy when I felt that it was the first time that my clients, my male clients, perceived me as a woman. The second dilemma, I called it universal discourse versus local discourse. Human rights discourse in the context of women's rights could be viewed at the eyes of the local society as a paternalistic discourse that aiming to impose Western values that would lead eventually and will harm women, while at the very same times, the very same discourse of human rights were used for the purpose of litigating cases on behalf of the minority group, and they didn't oppose the human rights discourse. But when we used the human discourse as women rights discourse, then it was opposed. The third dilemma, I called it national heroes versus community enemies. When we are dealing with issues concerning the minorities, such as home demolitions, recognition, issues that considered to be as national issues, protected the minority from Israeli policies, from state discrimination, then we, and I'm generalizing, me and other human rights attorneys were considered to be as national heroes. Our discourse was legitimate discourse. It was accepted among our community. But when we are daring to talk about what so-called internal issues, sensitive issues, dirty laundry that we're not supposed to talk in front of the of Israelis or the other, then our positioning was changed and we were considered to be as community enemies. Just week or 10 days ago, we were organizing a big conference at the Negev against the phenomenon of polygamy, and we were attacked on the basis of why you're doing that a week before election. Now we have to be unified. Now we have to protect the joint list. These issues, it's not the time. Leave them. Let's talk about these issues later. But then my response to that will be that women in a polygamous marriage that suffer from discrimination on a daily basis, they suffer before election, after election, and should be protected. And even if we are trying to be unified, we have to keep, and as a human rights attorneys and activists, we have to keep and talk about these issues constantly and regardless of timing. The second dilemma, I called it bargaining with patriarchy. It's the Dennis Kandiyuti and bargaining with the state. Basically, during our work as a human rights attorney, we are bargaining all the time. I mean, we want to spread human rights discourse. We want people to be familiar with the human rights discourse, but we have to bargain because and we have to compromise sometimes. So when we are bargaining with the state, it means that in order to, as for instance, there are a human rights organization that by principle doesn't engage in lobbying in the parliament, Israeli parliament, in the Knesset, and we were. And then it means that we have to meet with all kind of officials, ministers that we disagree with. Maybe they're not the most, I mean, we cannot consider them as human rights. And then we were meeting with them, for instance, when we met with Minister Benny Begin at the course of the Praver plan, when we were talking about the indigenous discourse, when we talked about Bedouin, that the UN basically recognized Bedouins as an indigenous community, and we talked about Bedouins as indigenous people, then it was like, this is the red line. If you're talking about indigeneity, it means that Israelis are colonialist. So, and if we're talking about more soft human rights discourse, like like liberal discourse of rights, it will be more acceptance. And then we had to choose our strategy in order to deliver human rights and advance the human rights of the unrecognized villages. This is on one hand, we're bargaining with the state, but on the other hand, we're also bargaining with the patriarchy, because when I represent mostly men in the Supreme Court in cases, and some of them are bigamist, hardly any women that come and participate. This means that I'm bargaining with patriarchy, and I'm bargaining with patriarchy because eventually I want to advance human rights discourse, and even in the price of adopting this discourse, this universal norms, into the local experience. It could be judged, it could be, we can argue whether it's good or bad, etc. Another example is the example of a Bedouin women participation at demonstrations against police action or home demolition, etc., which on one hand it's a positive act that we will see more women in the public sphere participating, but on the other hand we see that the physical separation between men and women are still there. We see one row men and the other row women, when most of the women are veiled or even with niqab. And then there is a dilemma. What our role? Should we leave this separation as it is, or should we, or are we basically cooperating with patriarchal norms? Okay. So should we compromise human rights? Arab-Bedouin women, to conclude, are perceived by the state as a homogeneous group. What is common to them is their experience of subordination to men. Because polygamy is justified as a traditional practice that has social legitimacy among young and educated Bedouin men, women cannot act against it, as their status in a patriarchal society is low and they lack any tools to change the situation. The power is defined in a binary way. Men are exploiters and women are the exploited. And our obligation is to challenge this binary distinction. State authorities benefit from the practice of polygamy among the Arab Bedouin because it keeps them preoccupied in their internal affairs. It is much more crucial for Israel to keep the Bedouin in the Naqab preoccupied with their own tradition than Arabs in other parts of Israel, because the state and the Bedouin population particularly are still in the course of land disputes. Thank you.
Thank you for really 3 great presentations on the intersection of human rights doctrine and discourse with non-liberal communities. And we see a lot of similarities and differences, so I hope we can have a good discussion now.